Good day, sir. I am Ma.Collen from BSN2R, and we, the Group 1, will be presenting Intellectual Property Law. Objectives. By the end of the discussions, learners will be able to: first, define intellectual property law and its relevance to nursing informatics. Second, identify and differentiate between the categories of intellectual property law, including patents, copyrights, trademarks, and trade secrets, within the context of nursing informatics. Third, discuss the importance of the right of privacy in nursing informatics, including its legal foundation and ethical consideration. Fourth, analyze how intellectual property law and the right of privacy intersect in nursing informatics practice, particularly in relation to patient data confidentiality and security. And lastly, evaluate strategies for ensuring compliance with intellectual property law and protecting patient privacy rights in the design, implementation, and the use of informatics system in healthcare settings.
Intellectual property embodies the ingenuity and creativity of the humanity, encompassing a vast array of innovations, expressions, and concepts that shape our growth. Protected by a web of legal mechanisms, including patents, copyrights, trademarks, and trade secrets, intellectual property grants creators and innovators a right to their work, fostering innovation, rewarding creativity, and driving progress in society and commerce. Intellectual property stands as a cornerstone of modern society. By affording exclusive rights to creators, intellectual property law serves as a catalyst for ingenuity, offering tangible incentives for individuals to dedicate their talents and to resource to the development of groundbreaking ideas and transformative products. These rights not only spur innovation, but also foster a culture of entrepreneurship. This egalitarian approach safeguards against monopolistic control and promotes a vibrant marketplace of ideas where innovation flourishes and breakthroughs are shared for the betterment of humanity. In this symbiotic relationship between creators and society, intellectual property emerges as a powerful tool for promoting economic development, cultural enrichment, and sustained progress.
Parts of the law under the IP Code. Part 1 is the Intellectual Property Office. This act is called the Intellectual Property Code of the Philippines. It sets up the administrative body in charge of enforcing intellectual property laws, which handles registration, examination, and enforcement of intellectual property rights. Part 2 is the Law on Patents. This section covers the legal rules for safeguarding inventions, including the requirements for patent eligibility, patent issuance, rights and responsibilities for patent owners, and the duration for patent protection. Part 3. The Law on Trademarks, Service Marks, and Trade Names. According to the Part 3 of the IP Code, trademarks rights are obtained through valid registration under the law. The registration certificate is valid for 10 years and can be renewed for additional 10-year periods. Part 4 is the law on copyright. Copyright is the legal protection granted to the owner of the rights in an original work. The Intellectual Property Code includes books, writings, music, and other works among the protected categories. Then the last part, Part 5, the final provisions. This section includes various provisions such as transitional arrangements, repeals or amendments of previous laws, and other administrative or procedural matters essential for the effective implementation of the IP Code.
The government organization responsible for enforcing the Intellectual Property Code is the Intellectual Property Office, which took over from the Bureau of Patents, Trademarks, and Technology Transfer. It is divided into 6 bureaus. First is the Bureau of Patents. Second is Bureau of Trademarks. Third is Bureau of Legal Affairs. Fourth, Documentation, Information, and Technology Transfer Bureau. And last, Management Information System and EDP Bureau.
Now let's discuss Republic Act Number 8293, June 6, 1997. An act prescribing the Intellectual Property Code and establishing the Intellectual Property Office providing for its powers and functions and for other purposes. Section 1, Title. This Act shall be known as the Intellectual Property Code of the Philippines. Section 2, Declaration of State Policy. The state recognizes that an effective intellectual and industrial property system is vital to the development of domestic and creative activity, facilitates transfer of technology, attracts foreign investments, and ensure market access for other products. It shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creation, particularly when beneficial to the people for such period as provided in this Act. All these creations are protected by the law, ensuring that the people behind it are given due recognition or remuneration for their effort.
Copyright. Federal copyright law protects original creative works such as paintings, writing, architecture, movies, software, photos, dance, and music. A work must meet certain minimum requirements to qualify for copyright protection. The length of protection also varies depending on when the work was created or first published. Trademark. Brand names such as Nike, Apple, as well as logos, slogans, and other devices that identify and distinguish products and services are protected under federal and state trademark laws. Unlike copyrighted works, trademarks receive different degrees of protection depending on numerous variables, including the consumer awareness of the trademark, the type of service and the product it identifies, and the geographic area in which the trademark is used.
The intellectual property right, known as the right of publicity, guards against the improper use of someone's name, likeness, or other indicators of their identity for profit, including their voice, signature, likeness, nickname, or photo.
Trade secrets. State and federal secret laws protect sensitive business information. An example of a trade secret would be a confidential marketing plan for the introduction of a new software product or the secret recipe for a brand of salsa. The extent of trade secret protection depends on whether the information gives the business an advantage over competition, is kept a secret, and not known by competition.
Enshrined in many international human rights instruments, privacy is a fundamental human right that is essential to the preservation of human dignity and the cornerstone of any democratic society. In addition, it upholds and strengthens other rights, including the freedom of association, speech, and information.
Patent. A patent is a form of intellectual property that gives its owner the legal right to exclude others from making, using, or selling an invention for a limited period of years in exchange for publishing and enabling public disclosure of the invention.
Trademark. It is a tool used to differentiate services and goods from one another. So forms are a word, group of words, sign, logo, or symbol. Copyright refers to the legal right of the owner of intellectual property. In simpler terms, copyright is the right to copy. This means that the original creators of products and anyone they give authorization to are the only ones with exclusive right to reproduce the work. So there are two types of copyright. So the first one is the economic rights. It enables a creator to receive profit gains should his works be distributed by third parties. And the last one is moral rights. It protects the connection between the creator and his works.
In summary, the field of nursing informatics is greatly influenced by intellectual property law, which offers incentives and legal protection for responsible technology usage in healthcare, innovation, and teamwork. To effectively manage legal and ethical challenges and lead the way in nursing informatics practice advancement, nurses and informaticists need to possess a solid understanding of intellectual property principles.